14, the general rule in South Africa is that the opinion evidence by witnesses is not admissible. It is irrelevant because it is the function of the court to draw inference and form its opinion from facts. The witness gives evidence as to the facts. The court forms its opinion from those facts. This is just a confirmation of my previous submission that I've just made, that this witness didn't have any insight as to relating to the facts. He didn't know what was going on. Maybe he was called to testify to confirm that the accused is competent to basically possess a firearm relating to accused number 2. So an issue that is not in dispute. We know he has all the required licenses. He's not being charged for that offense. I've already read the evidence relating to Section 22 and Regulation 21, what it states, but it's submitted that accused number 2, in his own evidence of this Mr. Wood, if he had insight into the facts and what had transpired from his own evidence, accused number 2, if you look at Section 110A, would have been guilty of an offense if the state had proved that he did indeed, if I didn't make that concession earlier, that the evidence is inconclusive of accused number 2 actually handing the firearm over to accused number 1. If I was able to prove that accused number 2 would have been convicted of a particular offense, if you look at Section 120, 10 in brackets A. So far as accused number 2 is concerned, I've already made my concession relating to him, and that I did not prove the case beyond reasonable doubt, and that the video relating to him handing the firearm over to accused number 1 or vice versa is inconclusive. But I'm obliged, as an officer of this court, to direct the court of the provisions of Section 257 of the Criminal Procedure Act if this court is not in accord with the state's assessment of the evidence insofar as accused number 2 is concerned. Despite my concession, Your Worship, you might find otherwise that you might not agree what I have just conceded relating to accused number 2. That's why this provision will become important, and it's my duty to assist the court to look at this provision. The section reads as follows: if the evidence in criminal proceedings does not prove the commission of the offense charged, but prove that the accused is guilty of an accessory after that offense, or any other offense of which he may be convicted on the offense charged. I want to repeat that again, because I think accused counsel for accused number 2 and myself will have a disagreement only on this particular part. That is the decision where the court have to make a particular finding. If the evidence in criminal proceedings does not prove the commission of the offense charged, but prove that the accused is guilty of an accessory